Good afternoon to all. A very warm welcome to Lawvs first National Moot Court Competition 2025. We are honored to have our learned judge in this courtroom, uh, Advocate Shri Arjun Kapoor. We welcome you, Lordship. Before starting with the arguments, we would like to brief the uh, Lordship about the functioning of the courtroom. I, Ritik Bhardwaj, will be the serving you as court master and will be assisting you with the maintaining the decorum and to assist the honorable bench. The court masters will act as facilitators between the bench and the counsel. The court master will time the arguments and intimate the bench accordingly. Your lordship is requested to please seek our assistance whenever it is required. As stated in the rules of the Lawvs first national moot court competition, each team will get 30 minutes to present their case, including 5 minutes will be given for rebuttal. And sub rebuttal will be given subject to the discretion of the honorable judge. Each team shall intimate the court master in regard to the division of time between the speakers. Only one speaker from each team shall be permitted for the rebuttal and sub-rebuttal round. So the order of presentation will be everyone is requested to please listen to this carefully. The order of the presentation is petitioner speaker 1 will speak first, then petitioner speaker 2 will speak. After that, respondent speaker 1 will speak, and following that, respondent speaker 2 will speak. Rebuttal, then petitioners will, any one of the petitioner will go for the rebuttal, and sir rebuttal, as I told earlier, will be upon the discretion of the judge itself. The judges may exercise discretion for extending the time for the oral round beyond the time. It's upon you, sir. It's upon all you. So let me make it clear. The team code for the petitioner is team code 77. Am I right? Please, you raise your hand.
Okay.
Team code for the petitioner is team code 77, and team code for the respondent is team code 49.
Okay.
And also, if someone is taking time for the rebuttal, I will you should mention it before the judge. Ask it before the commencement of the round only. And the total time is 50 minutes. And each speaker will be getting 10 minutes to speak. Speaker 1 will get 10 minutes. Speaker 2 will get 10 minutes. Whereas the respondent speaker 1 presenting the arguments will also get 10 minutes. And respondent speaker 2 will also get 10 minutes for speaking and 5 minutes for the rebuttal. I hope I am clear to each of the team members.
But I have a query that you said that
Yes,
there
sir.
will be 30 minutes. So how it can be concluded in 50 minutes?
Sir, the 5 minute time we have given is upon your discretion if you give sir rebuttal time to them or if you give
Okay.
extra time to them. So
Okay.
that's the
Okay.
small fraction we have kept for that.
Okay.
Yes, sir.
Very well.
So thank you, Your Lordship. Much obliged. So now I request the petitioners. Uh, First of all, I would like to seek the permission of the Your Lordship to start with the proceeding.
Yes. Yes, please.
So I now request the petitioners to start with the proceeding. Petitioners may please start.
Okay, sir. The council is here in the matter of Govindas and others versus State of UP
Yes.
and others under Article 136 of the Indian Constitution. The voice modulation is okay?
Yes. Yes. Just let me know who is speaking from your side.
Okay.
Participant number 1, participant 2.
Petitioner.
You may let me know. Yeah.
Participant
Participant
number
1.
1.
Yeah. Please.
Okay. With due permission, council would like to state the jurisdiction.
Please.
The appellant in the present case has approached the Honorable Supreme Court of India to initiate the present appeal under Article 136 of the Indian Constitution, as the present matter arises from petition challenging of or allowed acting the executive of Banke Vihari project. Within the council would like to brief the case.
Your voice is little bit breaking, but anyhow. Yes, please. Can you pardon this sentence, what you said just now?
Okay, sir. Banke Bihari Temple at I was stating the jurisdiction, Your Lordships.
Okay, okay.
May I brief the facts of the case?
Yes, please.
The Banki Bihari temple at Vrindavan is a major Krishna pilgrimage site attracting nearly 50 lakhs devotees annually. On 19th August 2022, during Janmashtami celebrations, a stampede led to a loss of 2 lives and several injuries due to overcrowding and inadequate infrastructure. Following this, multiple PIs were filed before Allahabad High Court under Article 226 seeking better crowd management and safety measures. On 20th March 2023, the High Court directed the state to implement a corridor project involving demolition of 300 structures and acquisition of 8 acres for wider access routes, emergency facilities, and crowd management. The petitioners, residents, shopkeepers, and conservationists contended that the project threatens livelihood, heritage character, and Yamuna River ecosystem, citing lack of public consent statutory clearances. The state argues that the project is necessary for public safety and orderly pilgrim management, having already spent over 300 crores in acquisition and planning. The matter now comes before this honorable court by the way of special leave petition under Article 136. That was the factual metrics of the case. With your permission, I will now move to the issues that fall for consideration.
Yes, please.
Coming to the first issue, whether the High Court's mandamus under Article 226 is a judicial overreach or is a valid step to protect life and safety. Our respectful submission is this: the construction of the corridor is not just a legal order, it is an executive policy involving planning and budgetary allocations. These are the matters which the Constitution has entrusted to the executive and legislature and not the judiciary.
Uh, Your Lordship,
And
I
so- yes.
I think that the time has already passed, and I think we should start with the respondents' side,
Okay,
if Your
somehow
Lordship
she was on
permits.
issue number one. Yes, we should start from respondents only, and still they have the time for rebuttal. They can cover
Yes,
up there.
yes, yes, Your
Yeah.
Lordship.
Over to the respondent now, please.
Over to the
Respondent number
respondents.
one, please.
Yes, Your
Yeah,
Lordship.
respondent side. Team 49.
Yes, sir. Your Lordship, I am appearing on behalf of the respondent, and Your Lordship, Council seeks permission to address this bench.
Yes, your respondent state, right?
Yes, sir. Speaker number one.
Okay.
Yes, Your Lordship. Your Lordship, if the bench is well versed with the facts, so the Council seeks permission directly move on the advance argument.
Yes, please.
Your Lordship, first issue is relating with the. Hello.
Please, any one of you may switch to off your audio, since I think you both
Everyone
are on the
else is
same.
requested to please switch off the video. Only the speaker will turn on the video, please.
Please continue.
Yes, Your Lordship. Your Lordship, the first issue is given whether the High Court mandamus under Article 226 directing a particular corridor scheme amounts to permissible micromanagement of executive policy or is a constitutionally valid exercise to remedy systemic failure endangering life and safety. So, in this, with the concern of the first issue, Your Lordship, uh, I am I'm disclosing the article 20, article 226 of the constitution, that the scope of the article 226 remedial, not restrictive, your lordship, and the article 226 of the constitution confers wide discretionary power upon the high courts to issue appropriate writs for enforcement of any of the rights conferred by part 3 and for the other purposes, your lordship. Your Lordship, in landmark judgment in Dwarka Nath versus ITO AIR 1966 SC 81, the Supreme Court has emphasized that Article 226 is couched in the widest terms and enables the High Court to reach injustice whenever it is found, Your Lordship. Therefore, the mandamus issued to ensure a safe corridor scheme is not an act of micromanagement but a legitimate constitutional exercise to enforce fundamental right, your lordship. In concern to the duty of the state under Article 21, your lordship, protection of life and safety. Article 21 guarantees the right to life and personal liberty. This right is not merely the right to exist, but only the right to life with safety, dignity, and without avoidable risk to life, your lordship. In the there is another landmark judgment, Your Lordship, in the Bandhua Mukti Morcha versus Union of India 1984 3 SSC 161, the court held that it is the duty of the state and correspondingly of the courts to ensure that fundamental rights are not rendered illusory for the weaker section of the society. When systematic failure endangers human life and safety in uh, congested or hazardous precise judicial intervention is justified as a protector of Article 21, Your Lordship. Your Lordship, uh, the
Can you
incident,
please
the
pardon the submission of this Bandhua Mukti Morcha? Can you please pardon the submission? What was led in this judgment?
Lordship, yes, Your Lordship. In this judgment, the court held that it is the duty of the state and correspondingly of the courts to ensure that fundamental rights are not rendered illusory for the weaker section of the society, Your Lordship.
Are not rendered? What was the word?
Was not rendered illusory.
Okay.
ILLUSORY
Okay.
for the weaker section of the society, Your Lordship. When the system failures endanger human life, Your Lordship, the safety is congested or hazardous pre-scientific judicial intervention or justified as a protector of a Article 21, Your Lordship. When we are talking about the judiciary duty to step in during system failure, Your Lordship, in there is another judgment which is passed by the Honorable Supreme Court in MC Mehta versus Union of India, which is relating to the oleum leak gas 1987 1 SSC 395. In this judgment, Your Lordship, the court recognized the principle of absolute liability and highlighted that protected citizens and hazardous conditions is a paramount constitutional duty, Your Lordship. Similarly, there is another same judgment, Paschim Banga Khet Mazdoor Samiti versus State of West Bengal 1996 4 SSC 37. The court held that the right to life includes the right to timely medical care, imposing a positive obligation on the state, Your Lordship. So the incident which was occurred in the Vrindavan, Your Lordship, in relation to recognizing the corridor, the stampede was occurred due to the heavy rush in the corridors of the Vrindavan, Your Lordship. The stampede was happened. There are two people who are died and 25 to 30 people they were injured into that stampede. So that was the very unpredictable situation was occurred in the Vrindavan, due to which the state the High Court has been used their discretionary power with filing of the writ petition under Article 226 mandamus, and the High Court has categorically give the decision for making the corridor in the Vrindavan, Your Lordship.
Okay, your submission concluded. What Speaker 2 has to say?
Your Lordship, the council, the first council will deals with the two issues, and the remaining two issues will be
Okay, so you were
handled
only on
by
the
the
first issue and
other.
you have cited the judgment on the very first issue, right? So the second
Yes,
issue
Your
is still
Lordship.
remaining with you.
Yes, Your
Okay,
Lordship. The council seeks
please.
permission to move on to second issue, Your Lordship.
Yeah, but before moving
The
to the
second,
second conclusion, I am still on the view that the judgment you have cited. So anyhow, I'll conclude in the last. Let your second issue be also concluded. Then give you the okay. Second, your issue, please.
second issue, yes, Your
Address
Lordship.
your
The
argument on the second issue.
much obliged, Your Lordship. The second issue is whether configuration of temple approaches, allies, and religious circulation routes implicates Article 25, freedom to practice, and Article 26, management of religious affairs, and if so, the correct test to distinguish faithful facilitation from unconstitutional interference, Your Lordship. So, in relation to the second issue, Your Lordship, the no absolute right under Article 26 and 25 and 26, Your Lordship. Article 25 guarantees freedom of conscience and the right to freely profess practice and propagate religion. But this right is expressly subject to the public order, Your Lordship. Morality, health, and other provisions of Part 3, and the Article 26, Lordship, allows religious denominations to manage their own affairs in matters of religious, but again subject to the public order and morality and health, Your Lordship. Therefore, configuration of external access routes to temple does not infringe essential religious practice, but rather facilitates safe and orderly access, consist with Article 25(1), Your Lordship. Your Lordship,
Okay.
configuration relates to secular, not essential religious function. The test laid down in the several cases is the essential religious practice doctrine. The court examines whether a particular practice is integral to the faith itself or not. So, in the particular judgment, Your Lordship, in Sri Adi Visheshwara of Kashi Vishwanath Temple versus State of UP, Your Lordship, in this judgment, the test laid down in the Supreme Court upheld the state's power to intervene in secular aspects of temple administration and even restructure the management while leaving core religious practices untouched. Similarly, winding allies, creating regulated circulation routes, and restructuring approaches to the shrine are secular, facilitative measures, not interference in rituals or model of worship. And
When
in
was the
relation
judgment
to the,
passed?
yes, Your Lordship, the judgment was passed 1997. The citation is 4 SSC 606, Your Lordship.
Okay.
And Your Lordship, faithful facilitation of worship, not interference. The correct test is whether the state measures aids orderly access and safety without altering essential rituals. So, applying the same principle here, the ritualistic core, darshan, puja, and offerings is untouched. Only the logistic of access and circulation are being restructured for safety. This is faithful facilitation, not unconstitutional interference, Your Lordship. So,
Okay.
So sorry for
conclusively,
the
Your Lordship.
interruption, Your Lordship. So sorry for the interruption. The 10 minutes for the speaker one has been passed. Now it's turn for the speaker two. If your Lordship may allow them to speak for a few more minutes, it's upon the discretion of your Lordship.
Only in 2 minutes you can conclude that why you are on these issues. Just you may conclude by pressing those issues that what is now the essence to state to
Oblige, Your
intervene in
Lordship.
this matter. Just conclude
Oblige, Your
and
Lordship.
justify the court that why court should hear you out.
Yes, Your Lordship. Oblige, Your Lordship. Your Lordship, as conclusively, I'm concluding my argument in relation to the two issues. If does not infringe essential religious practices, Article 25 and 26 remain intact. Falls within the state power to regulate secular aspect through temple administration, enhances the right to worship by providing safe and efficient access. In the line of the judgment, Your Lordship, Ismail Faruqi versus Adi Vishwara and Adi Sivaswa Shankaracharya, which distinguish between essential religious practices protected and secular logistic and arrangement regulates, Your Lordship. Therefore, the correct test is whether the state intervention alters essential rituals, since it does not, the recognition is faithful facilitation, not constitutional interference, Your Lordship. The whatever the steps has been taken by the Your Lordship by the state, that was the favorable steps were taken by the states in favor of the public, because due to which the whatever the incident was occurred in the Vrindavan in relation to the stampede. So that was the very
Okay.
problematic concern for the peoples of the India, Your Lordship.
Okay. Okay. You may have concluded. Over to the speaker two then.
Yes, sir. Much obliged. Council seeks to permission to give the council seeks permission to
Yes.
move on the speaker number 2, Your Lordship.
Please, speaker number two. Please. Sir, unmute yourself. You are not audible, sir. Please unmute yourself.
Yes, thank you, sir. Much obliged, sir. The council to seeks permission to present issue number 3 and issue number 4.
Yes, please.
Sir, issue number 3 is related to whether the state objectives of fraud management and public safety under Article 21 justify large-scale demolition and redesign of an originally evolved sacred monuments which less restrictive alternatives staggered darshan and tech-enabled flow and festival time regulation may exist. Why the restrictions is required? So, on this issue, the submission is that the Article 21 imposes a positive duty on the state to ensure safety of life. The right to life under Article 21 is not only negative, arbitrary deprivation, but also positive, requiring the state to take proactive steps to prevent hazards, stampedes, and disaster in crowded religious places. The state cannot wait for tragedy; it must be proactively. And that's why in Olga Telgi versus Bombay Municipal Corporation under Article 21, it was stated that under Article 21, it includes the duty of the state to protect life in its fullest sense. And the public safety is a constitutional valid ground to recognize sacred monuments, which
Then I objected at the judgment you just quoted. In which court it was held? Which year? What was the citation? You have not told.
sir, it is in Supreme Court 1985, citation
Okay.
number 1985.
Honorable Apex Court. Okay.
Yes, sir. Yes, sir. The and the it is related to the state's protection of the life because the Article 48A and Article 51G also mentions that Article 48A is related to separation of power. So it is the duty of state to take all the measures which protect the people which are going to the some monuments or some religious temples, and if there is no proper protection and there is no safety, then it is fully responsible to state to do such measures and protect the people and citizens. And that's why the case, the issue number 3 is related to imposing taking action by the state. The public safety is a constitutional valid ground to reorganize sacred space where lakhs of devotees. Crowd management is a public order and safety issue, not merely administrative convenience, since Article 25 and 26 are expressly subject to public order, morality, and health, and the state is constantly bound to recognize all those things. In a second case, the state Supreme Court has decided that in uh, Acharya Jagdish Vardhanan versus Commissioner of Police Calcutta, citation number 1983 for SSC 522, where the religious practice can be regulated if they threaten public order or safety. And that's why state has taken all the measures by organizing measures like that, public safeties, then organizing crowd management in better way, and that step has been taken by the state in a proper way. A state is the best place to assess necessity, and courts exercise limited review on that case. It is not for courts to substitute their own judgment on technical issues like urban planning, structural safety, or crowd flow. Judicial review examines arbitration or malafide, but not the wisdom of the policy. This is the duty of the state to decide whether the policy is implemented in particular segment or not. Then the second submission is that it is the fundamental right of worshipper, not support of the redesign. And large scale redesign may be proportionate where risk is systematic. So one of the other decisions taken by the court, the Modern Dental College versus the State of MP, the court adopted the proportionality test. Restrictions are valid if they serve a legitimate aim, are suitable, necessary, and balanced. The state redesign meet this standard. So now I'm going to the issue number 4. May I take permission for
Yes,
presenting issue number 4?
yes, yes, please.
Much obliged, sir. The issue number 4 is related to whether the absence or inadequacy of meaningful public consultation, like the citizens, shopkeepers, religious bodies, environmental experts in that particular segments or domain, renders the decision-making process arbitrarily under Article 14. Article 14 says that equality of law. And that's why before taking any decision by the state, the state has taken all the consultancy in this case before proposing a prototype design for the Brindavan corridors, like the what is implemented by the state of UP in Kasi. The Article 41 strikes against arbitrary state action. However, judicial review of executive decision is limited to legality, rationality, and procedural fairness, and does not require court to ensure exhaustive consultation in policy matters. In the case of EP Rappa versus State of Tamil Nadu in 1974, for SSC 3, it is stated that the arbitration is unethical or to equality, but limited judicial review applies to policy decision. In the same way, the Menka Gandhi versus Union of India in 1978, 1 SSC 248, it was stated that the procedures must be fair and reasonable, but the state has discretion to in determining the scope of consultations. Then it shows that it is the duty of the state to design the case, to design the consultancy, and what are the factors is implemented in designing of the corridor. It is the duty of a state, not the, because it is a technical matter where the environmentalist and other factors are also involved. So consultation is desirable but not always mandatory. So the petitioner side, what is projected in that,
Mr. Counsel, hold on. Just now you said that since the environmental measures are necessary, but it's not mandatory to seek the consultation. You just said that once you're admitting yourself that since it is necessary, so why didn't become necessary to consult with the person environmental specialist? If
Sir,
you are saying so.
thank you for your thank you for the enlightenment, sir. Consultancy is desirable, but not always mandatory. It is the statement, sir. Mandatory means where it is really technical needs is required, where it is really required some technical aspects, the historical data is required, then consultancy is required. For planning a township, where there is always problem of fairness, there is a problem of some death, there is a problem of disasters. So it is the measures of the government of state of the UP, and in a state of UP there are a consultancy mechanism. They have decided how to plan corridors, and the same prototype has already implemented by the state of UP in Kasi, and there is no objection from the citizens. So that's why it is in planned phase, and it will be implemented based on the consideration of the factors of the resident also. So the state has taken all the obligations where there is no any type of fear to the citizens. So that has been considered in this case. So the state conducted reasonable consultation with the key stakeholders, not every shopkeepers. It is a much, then the planning and then implementation, then execution of any project will take a long time. And so the whoever the stakeholders in that case has been already consulted by the state mechanism. In one more case, in Akhil Bharatiya Congress versus State of UP, limited but reasonable consultation satisfies Article 14, but it is not constitutionally required.
Sir, again, in
So,
this case, you didn't mention and in which year it was decided, by which court it
sir,
was decided.
sorry, sir, it was decided in 2011, citation number 5, SSC 29. The policy measures have a clear rational nexus with the objective of preventive stampedes and accidents. They are proportionate
So
to the
sorry
threat.
to interrupt, Your Lordship. I'm so sorry, but the
Yes.
time is over. If Your Lordship may give him some
Just
time, it's upon
give
the
him 2 minutes more to
Okay,
conclude.
sure.
Yeah.
Sure, Your Lordship,
Please.
it's upon you.
In 2 minutes, you may conclude this particular issue, that how this action of the state, just read your issue once again, and the issue was that how the state is justified in getting all these things. Just conclude.
Sir,
Give me your
thank you, sir.
conclusion.
Thank you,
Rather,
Lordship.
give me the conclusion on both your issues.
Sir, I'm talking on the issue number 3 and 4. State has make a system where there are technical experts, there are environmentalists, there are many experts in different domains who are the planners of any city. So the planning department, then other departments who is involved in this prototype design for the corridor is already involved, and they have taken multiple steps before designing a corridor for the Brindaban. And based on the based on the historical data, where they have already seen that the millions of people are coming to the Brindaban in particular month, where then there is a festival of Janmashtami, Holi, and other festivals. Millions of people are coming. So in that time, there is a disaster that can be happen. So a state cannot wait for the every citizens, every shopkeepers to take their consent. After that, they can design the prototype. So it is the duty of a state to first take the article number 21, which is the most important part of this case, because life and liberty is the important aspects for the government. So if anyone, if a single person will collapse in future, that will the full responsibility to the state, and that's why the state has taken this decision. On the submission of that, I want permission to uh, present a prayer in this case.
Please.
So, in view of the facts and circumstances which is presented, I pray before the Honorable Court that it may be pleased to dismiss the special leave petition filed by the petitioner as being devoid of merit, uphold the judgment and direction of the Honorable Allahabad High Court, mandating the timely execution of the Bake Bihari Temple Corridor project. Third, declare that the proposed corridor project is constitutionally valid, being consistent with Article 21, 25, 26, and 14 of the Constitution of India. Fourth, hold the project representation a reasonable, proportionate, and necessary measure for the protection of life and safety of the lakhs of devotees. Fifth, recognize that the regulation of the temple access and circulation routes in a secular function which does not infringe upon religious freedom under Article 25 and 26. And last one, pass any such order as the Honorable Court deem fit in the interest of justice, equity, and good consensus. Thank you, sir.
At the last, from both of you, Team 49, I would like to ask a question about your main emphasis, that how can you justify in a very single about your all of your points, which point you will press for main issue of all these issues, that how can you justify the demolition of a large number of buildings and at a sacred places where there are already very narrow roads, when you are not in the consultancy with the shopkeepers and the native residents also. So how will you justify that the state is right at their end to demolish this large area? Any one of the most important point amongst your arguments, which point do you say that because of this such particular reason we are justified, that state is justified in such a big demolition and restructuring that entire scenario?
Sir, Article 21, it is the most important article for this case, because life is important. Without life, anybody can, we cannot value the life. Value addition of the life cannot be based on the whatever crores of rupees we can invest. But if one single person is dead, then the complete whole scenario will be changed. That the brand image of the state can be changed, and that's why the Article 21 is the important factor in this case.
Okay, very well. And speaker number one, about you?
Yes, Your Lordship. Yes, Your Lordship. The same in respect of the Article 21, as the speaker number two, he has mentioned that the Article
You are
21
also on the
is
same
not.
line, means
Yes, yes, Your Lordship.
you adopt his argument. Okay, then. Thank you. You have concluded.
Yes, Your Lordship.
Now,
Authorized, Your
Your
Lordship.
Lordship, now it's time for the rebuttal round. Team 77, team code 77, please turn on your camera and video. And team 49, please turn off your mic. Team
Team
77, are we
77
audible
haven't
and visible?
argued their even issues also yet. If you can just argue in within very limited time, I can grant you, because I want to hear you out also.
Am I allowed to address all the four
Yeah,
issues?
yeah, please, please. I want to give them some time. Is it possible, Ritik ji?
Yes.
Master, I'm giving some time. Yes,
Yes,
because
yes, Your
we
Lordship.
haven't heard them. We haven't
It's
heard
upon
them.
your
Yes.
discussion. Yes.
Okay.
Coming on to the first issue directly. So the respectful submission is the construction of corridor project is not just a legal order, it is an executive policy decision involving planning and budgetary allocation. That was the matters which the constitution is interested to the legislative and executive and not the judiciary. In the case of Narmada Bachao Andolan, it was clearly stated in para 229 that it is now well settled that the courts in exercise of their jurisdiction will not transgress into the field of policy decisions, giving emphasis on whether to have an infrastructural project or not, and what the type of the project is and how it has to be executed are all a part of policy decisions, and the courts are ill equipped to adjudicate on a policy decision so undertaken. The same thing was observed in the case of Asif Hamid versus State of Jammu and Kashmir, where the court had said that the have meticulously defined that the functions of various organs of the state, the constitution does not permit the court to advise or advise or direct the of execution. Similarly, in the case of Aravali Golf Club versus Chandarhas, the court even warned that judicial activism must not become judicial adventurism. Your Lordships, the writ
Please,
of
all the citations, please, the citations you are citing, you're not stating the citation as well as the court which passed the judgment. It was a High Court, Honorable Supreme Court, single bench judgment.
it
Though
is
I know
mentioned.
that it's a positive time, but please, if you are referring a judgment, please refer to the complete citation along with the court passing these judgment.
Lordships, it was mentioned in the memorial, so
Okay.
the writ of mandamus, by its very nature, is to command. It obliges the executive to perform a certain duty that the law has already imposed. The literal and established meaning of mandamus does not empower the court to step in and do the exact same thing. It simply directs the authority to act according to the law. However, in the present case, the High Court has gone beyond issuing a command. It has itself directed the execution of a corridor project, deciding on to what, how, and when it should be implemented. This concludes the submission on my first issue. I would proceed to the next issue now. The next issue
Okay.
pertains to the religious freedom under Article 25 and 26 of the Indian Constitution. Your Lordships, while examining the exact scope of Article 25 and 26 of the Constitution, it has become very clear that fundamental rights of the petitioners, the right to practice their religion under Article 25 and right to manage their religious affairs under Article 26, have been clearly violated. Moving on to some landmark judgments which the courts have clarified that what activities actually fall under the ambit of religion and practice of religion and how the courts have interpreted. In the case of Commissioner Hindu Religious Endowments Madras versus Sri Lakshmi Indra Tirtha, of in that case, the citation
Anyhow,
1951
which court held this?
is your Lordship?
Which court held in this judgment? Which court dealt with this judgment?
Supreme Court,
Okay. Honorable Supreme Court.
Honorable Supreme.
Yes,
It
please.
was observed that Article 25 and 26 is sufficiently clear to enable us to determine as to what comes within the purview of religion and practice of religion. The Article 26 Clause B empowers that the religious organizations enjoys complete autonomy in the matters of deciding as to what rites and ceremonies are essential to the tenets of the religion they hold. Similarly, in the case of Sishamal Others versus State of Tamil Nadu, the courts observed that the protection of article under 25 and 26 of the Constitution is not limited to the matters of doctrine or belief. They also extend to the acts which are done in persuasion of the religion or which are the integral, which later forms the integral part of the religious practices. The same thing was observed in the case of Sri Adi Visheshwara of Kashi Vishwanathan Temple of State versus State of UP. The court observed that Article 25 and 26 must be viewed with pragmatism. Thus, we contend that the Vrindavan's sacred alleys, the temple approaches, and the parikrama routes are all indispensable to the religious observances and the spiritual discipline of devotees. The proposed reconfiguration will dismantle these practices, thereby infringing the petitioner's Article 25 and 26 of the Constitution. With the due permission, the Council would move to the third issue.
Please.
Whether the state's objective of crowd management and public safety justify large-scale demolition. The respondent seeks to justify a large-scale demolition in the name of public safety. With due respect, we submit that such justification is not constitutionally valid. Right to life under Article 21 is wide and far-reaching concept, but the major and equally important facet of that right is right to livelihood. If right to livelihood is not treated as a part of constitutional right to live, the easiest way of depriving a person to his life would be to deprive him of his means of livelihood till the point of abrogation, as this was observed in the case of Olga Tellis versus Bombay Municipal Corporation. Even, your lordship, past tragedies of greater magnitude have occurred, but no such drastic step of demolition has ever been contemplated. In the case of Mandar Devi stampede of 2005, where over 300 pilgrims lost their life. Similarly, in the case of Keshar Singh and others versus state of Uttar Pradesh, arising out of the alleged stampede at Mahakumbh this year, 30 people lost their life in that case. Still, no such precedent where mass demolition has been ordered. Rather, in response, remedies which sought and orders have been made, like they were only extend to inquiry, administrative commissions, or the compensations. So this demonstrates that accepted practices, even in face of heavy casualties, is to adopt that less restrictive measures and proportionate measures shall be taken into consideration. So such an approach fails the test of proportionality, which was held in the which is now the part of Indian Constitution under Article 21 and 48A, and this proportionality doctrine was included in the case of Vellore Citizens Welfare Forum versus Union of India. So the main contention of ours is that there must be some reasonable nexus between the object and the means which are to be achieved. So here the object is safety from a possible stampede which may occur in the future, while the harm here which is certain, the demolition of houses, the demolition of two houses of 200 people, 500 businesses are at stake. So the harm here is immediate, massive, and very certain. So while in comparison to that, the danger sought to be is very preventive and is speculative, and that can be addressed by far less drastic measures. So which are detailed at para 22 in our memorial. Assuming arguendo that the area around the Banke Bihari temple forms a part of designated heritage zone under the AMASR Act, under which if we read section 20A along with section 20C, it is clearly stated that any construction activity within 100 meters of the monument falls within a prohibited area. Even if we look at the exceptions where certain projects can be carried out, it is still said that in clause 3, section 20 of the Act, that any projects
Your
which are to be
Lordship, sorry to
Please.
interrupt, but Your Lordship, if with your
Now we
permission,
should come to rebuttal.
yes, Your
Now we
Lordship,
should come to rebuttal because it's already time. Yeah.
yes, Your
You may
Lordship.
please come to the rebuttal. The citation they have also put it. You may please rebut the issues.
Your Lordships, the council, the statement of facts in the memorial of the council, they stated that Banke Bihari temple witnesses lacks of duties daily. This is contravention to the statement. This is contravention to the statement of facts. Again, they mentioned in the memorial that the Allahabad High Court had taken suo motu cognizance. Instead, um, instead PILs were filed under Allahabad High Court, in the Allahabad High Court. Suo motu cognizance
Very
was
well.
not. So this was the contravention to the statement of facts. Again, they contended in their memorial that timely implementation of corridor project, your lordship, this is a permanent implementation, not a timely implementation. So the statement of facts are not neutral in this case. Moreover, the respondents had relied on a series of decisions on which the relevancy to the present matter is not seen. Cases such as Bandhua Mukti Morcha and Paschim Banga Khet, Narmada Bachao Andolan was all decided in vastly different manner. Like they have taken the
Very well.
contention in very broader sense. So none of which are concerned with the demolition of religious property, and these are the submissions which we feel, and even in the memorial submitted by the respondent side from the petitioners, we can say that they are themselves considering that the decision taken by the Allahabad High Court is constitutionally valid. So when they themselves admit that the decision taken by the Allahabad High Court is valid, then why are they challenging the same in the Supreme Court?
Okay.
Your Lordship, if you have any questions, we can go with that, or we can go for the sir rebuttal round, giving the respondents a chance to tackle that?
I had one question, but anyhow, we can go for a sir revertal then,
Your Lordship, if you
please.
have a question,
No.
we can
I'll
go.
address them. I don't have any just queries, but I'll address them some reasoning in the last stage to both the parties.
Sure, Your Lordship.
Yes,
So,
respondents, you have to say anything? Team 49? Team 49, we hope we are audible to you.
Yes, sir. Yes, sir.
The
Uh,
petitioners have submitted their claim. They have rebutted that none of your presided judgments are citing the actual issues. They are not into it. They are saying state is not justified in demolishing the large number of demolitions being made into a private sacred temple, which has been since ages. And what you have to say in this?
Sir, any decisions taken by the state government is on the basis of the requirement of the various community in the society. So the if we'll think about the Ram Mandir temple, we can think about the Baki Bihari temple, we can think about the Kasi temple, Varanasi temples. So everywhere the government has decided on the urban planning. We have already planned because the potential of the growth of the population in the state of UP is growing high, and also the concern is that in every particular segment when some festivals like Holi, like Janmashtami, like Sivaratri, the crowd is very high that cannot be managed in such a particular narrow escapes. So that's why in multiple times it has been seen, and already our council too, our petitioners had council has already told that multiple times such type of stampede disaster has already happened, and the government has taken some measures, and the investigation has been done, and some based on the investigation a report has come, and some measures has been taken. But that was not the solutions, because it is the first and foremost duty of the government to protect and the people's life. Even they are on the deathbed, that is the government cannot allow that they can go for death by the taking actions. So already there are multiple judgment on that, the article 21, and the article 21 has been extended in multiple way, like dignity, like privacy, and like when multiple it was extended by the honorable supreme courts in different PIL and different judgments. My question with the council is that they are saying that only they can take some measures, but they cannot demolish the buildings where the some 200 shopkeepers are doing some businesses, because the precedent is that already in Ram Mandir area, Ayodhya, in Kashi, that type of prototype has already implemented by state of UP, and they have seen there is no objection, and after that there is a growth of economical development in that particular area. And whatever the decisions taken by the government in that design of the corridors, it was all the concern of the state stakeholders has been considered, and based on that that design has been done. Regarding the implementation and the permanent aspects, what the council too has spoken that this is the permanent measures. Yes, it is required permanent measures, because government is talking about after 50 years, after 20 years, what will happen of that scenarios. So only on the consideration of the business and the religious, such decision cannot be avoided, and that's why whatever the decision taken by the state of UP in this corridor project, based on the historical data, based on ASI recommendation, based on the urban planning recommendation, it is correct. And from the council respondent side, the decision of the state of UP is correct.
Okay, so the respondent number 2 also had to say something, or can we hear your submissions? You adopt his argument, or you want to say something else? Can we conclude now?
No, sir. The speaker number two, he has concluded. So I'm on the also on the same line.
Have we concluded? So can I say something to both of the participants?
Yes, thank you
Yes,
so
sir.
much for that, sir.
yes, Your Lordship, you are requested to please provide your valuable feedback or any queries if you have.
See, very well presented by both of them. since the petitioners was to speak first, but due to the technical issue, we couldn't hear them out. And otherwise, your presentation and everything was very good. Both of you did very well. You all knew the facts. You all read it, gone through thoroughly. But what I want to state is whenever you are addressing any arguments, and this is a real time practical experience, you have to now, since you are there, you have to be on this chair once. One or the other day you have to hear, and for that you have to address the arguments by referring to a particular judgment. Thereafter, you have to refer the citation along with the judgment is passed by the honorable. It's always used as the wording as the honorable for high courts and the supreme courts. They are the precedent makers for the lower courts. So whatever they passes is the precedent for the lower courts. You have to run on the same way and on the same path. So always cite that. Secondly, both of you missed one thing, which I, being a legal practicing advocate as well as judge, wanted to know that you both are admitting that a stampede took place in 2002. The petitioners didn't told to this court that we took any action in relation to that, sir. Thereafter, it will not take again. We have already taken the measures. We are still on the measures. I saw your memorial. There was the statement that around 5 lakh tourists visit there, whereas the respondent was only on the view that the population of UP is increasing. It's not that only the UP citizens are visiting the premises. You were open to say that yes, the tourists from all over India, even the outsiders visit to the temple. And on that said, the respondent could have objected, Your Lordship, if they themselves are you said the point that yes, the petitioners are saying that these stampede are taken place in year back also. You took that point, but you didn't say that what measures have the petitioners taken yet. The state, why the state is intervening in between, why the state want to have a huge demolition being conducted, because the petitioners failed to address the public security and safety under Article 21. That is why state is intervening. So these are some memorials. This is not only a chapter in wherein we have to do a reading. You, being an advocate, have to take the fact as if it is your own case. You have to recite it. You have to recite each and everything. If the judgments are given to you, you have to go thoroughly. And the petitioners counsel, if the judgment were given to you, you could have thoroughly gone through the contents of that judgment, in which context it was being passed, when it was passed, and like the respondents had, the respondent very thoroughly stated each and every judgment with the year wise. I noted down it, and that is I expected from you also, that from the very first judgment, thereafter the latest judgment of the Honorable Supreme Court, because in the changing era of the time, even the judgment needs to get changed, and that is our Honorable Supreme Court does. So otherwise, you guys are very well. You presented very well, but in the real-time arguments, you have to keep and bear in the mind that this isn't it a moot court. It's a factual situation wherein we as an advocate have to address complete arguments. You still got very much time in the High Court and Supreme Court. You have to just crux out the matter. Just what was the conclusion? Like, for example, don't take me otherwise, but I'm still saying you, like there was two issues given to the each one of you. Now, among those issues, you have to conclude by saying, Key Lordship, by these reasons, I rest my case with the support on my issue. Again, that issue has to be represented, refaced, requoted that yes, I support my court because that the state was validated in such demolition, and the petition said that yes, the state is not justified in demolishing because the stakeholders' consent was not taken. Only because of the recommendation of any committee, the large number of public may be adversely affected. So you guys can have more enrichment on this next time. Best of luck to you. Very well.
Thank
It was a
you.
very nice, and I'll give the courses.
Mobilize, Your Lordship. Mobilize, Your Lordship.
Thank you so much, Your Lordship, for such enlightening words and for motivating these young minds. And thank you so much, Your Lordship, again for giving your valuable time to us and for bearing with us for because of some network issues, because of some delay. You were being very cooperative, sir. Thank you so much. That's an honor to have you here. Thank you so much, sir. I request all the participants to please leave.